Hi everyone, welcome from Law with Dunk, the Law Guy, and today is day 26 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. If you have a case you want me to cover, always feel free to drop any requests in the comments section. With today's case of R.V. Evans 2009, I'd like to go back and cover another omission case. You'll remember from the very first recording when I covered R.V. Pitwood that an omission is a way in which the actus reus of a crime, i.e. the guilty act, can be committed, provided the defendant has a duty to act. The case of R.V. Evans 2009 helps provide another example of a duty the defendant has to minimise harm after creating a dangerous situation. Obviously, this duty was covered in the Day 5 recording with the case of R.V. Miller 1983. This duty is otherwise known as a duty which arises due to the defendant setting in motion a chain of events. In R.V. Evans 2009, the victim was aged 16 and sadly was a heroin addict. The victim lived with her mother and her older half-sister. The older half-sister was the defendant for the purposes of this case, as she had purchased some heroin which the victim later went on to self-inject. The victim sadly then went on to overdose. The mother and sister put the victim in bed rather than summon medical help. They had hoped that the victim would recover, but instead she died. The mother and sister, the defendant here in this case, were both convicted of gross negligence manslaughter. The duty owed had been breached, which caused death, and the defendant's conduct carried a risk of death, and was also grossly negligent. Thus, the 4 steps of the gross negligence manslaughter criminal liability structure were proven. It's clear that the mother owed a duty of care to the victim, as the victim was her daughter, i.e. a duty by way of a special relationship, which can also be seen within R.V. Gibbons and Proctor. See the Day 2 recording there. However, the defendant, the older half-sister, appealed, arguing that she did not owe a duty of care to her sister. The defendant's conviction at trial was upheld on appeal in the Court of Appeal on the grounds that the defendant had created a state of affairs which posed a threat to the victim's life, and therefore Evans owed her younger sister a duty. You could also argue that Evans placing her sister to bed to recover rather than summon medical attention was a voluntary assumption of a duty. However, duty to minimise harm probably fits better. And that's it for today. Thank you from Law with Dunk, the Law Guy, and I'll see you tomorrow.